Okay. Okay. So just to introduce myself for the purpose of the recording. So Gavin Davidson, Professor of Social Care at Queen's, and this presentation was put together along with Bernadette Hamilton from the Approved Social Worker Programme, and James Todd is my co-presenter, who'll take you through the applied aspects of the training this morning. James is and the training team in this Southern Trust is also chair of the assessment panel for the Approved Social Worker Programme. Okay, so the training is about the Mental Health Northern Ireland Order in 1986 and the modifications made to it by the Coronavirus Act 2020. So this first part of the training focuses on the law and guidance. Okay, so we'll work through the Mental Health Northern Ireland Order 1986. I'll refer to it as the 86 Order and the modifications to it made by Schedule 10 of the to the Coronavirus Act 2020, which I'll just call the Coronavirus Act. Schedule 10 is worth reading. I mean, that's the sort of the core of the modifications to the 86 Order. It's on page 116 of the Coronavirus Act. You've hopefully already received the resources along with these presentations, but the resources for this part of the training are the 86 Order itself and the 86 Order's Code of Practice, and this set of prescribed forms to be used under the 86 Order. I've also sent, although you probably have already, the regional risk assessment guidance. It's called Promoting Quality Care and the tools associated with that. You should have also received the Coronavirus Act itself and its explanatory notes. And crucially for this role as a relevant social worker, the 86 Order Emergency Code of Practice, which is providing in maybe more accessible language the modifications made by the Coronavirus Act to the 86 Order. And also crucially within the emergency code are the two things you need to complete as a relevant social worker to apply for somebody to be admitted for assessment, which are the emergency form 2 and the relevant social worker statement, which is form 2A. In parts 2 and 3 of the training, James is going to take you through the assessment process in much more applied depth. And just to note that you should also have received the resources for that part of the training, which are the regional guidelines audit and implementation networks, guidelines for the 86 Order, RQIA's guidance for the completion of the prescribed forms. Also really importantly is the regionally agreed format for the applicant's report. It's also referred to as Mental Health Order B. That's the report you need to complete after you've assessed someone to determine whether you should apply for them to be admitted or not. You should complete that regardless of the outcome of your assessment, and there's guidance about what you need to include in that report. It's well structured and it's worth having a read through that report because it prompts you to think about all the things that you need to be assessing. There's also associated with the assessment process part of the training, the regional interagency protocol. That's really helpful for thinking about your liaison with the police and ambulance service, especially who might be involved in these assessments. And then the third part just works through two applied examples. Okay. So the key learning objectives for the training are to further develop your knowledge and skills relevant to assessments under the 86 Order and also the temporary modifications made to it by the Coronavirus Act. Something we'll cover repeatedly, which you're probably already familiar with, but it's at the absolute heart of this process are the criteria for compulsory admission to hospital. So we'll repeat that a few times. but it's really important that you have a really good grasp of the detail of those criteria. We'll work through the process of admission, the process of assessment for admission for assessment, and the ASW's role in the assessment process and the relevant social workers' role in the assessment process. They're not dramatically different, but we just need to sort of clarify what those differences are so that you're aware of them. All the factors that you need to consider in the assessment process, and then some applied examples. Okay. We've sent through most of the directly relevant law and guidance that you'll need, but this is just to acknowledge the wider legal framework. So you have the 86 order itself, and there's also a guide to that, which we haven't sent, but we've included aspects of the guide which are directly relevant. You do have the 86 orders code of practice, which is really helpful source of guidance. Also relevant is the Capacity Act, which was partially implemented from December last year. I think in an earlier version of this presentation I'd put December 2020 by mistake, so if you have the earlier version, please correct that. It was definitely December 2019. So the partial implementation was for interventions which amount to deprivation of liberty. And if the mental health order, if the 86 order applies, the Capacity Act doesn't. So if the 86 order applies, then it should be used. As you know, partial implementation of the Capacity Act is just for interventions that amount to deprivation of liberty. So the common law is still relevant for interventions that don't amount to deprivation of liberty. So that's in the circumstances where you have a reasonable belief that a person lacks the capacity to make this specific decision, and the intervention being proposed is in their best interests. So there are still aspects of intervention that may come under that the person doesn't meet the criteria for the 86 order, but you might still be considering intervention that amounts to deprivation of liberty under the Capacity Act, or intervention that doesn't amount to deprivation of liberty, which would be under common law. For any of these processes, the Human Rights Act obviously applies and is relevant and needs to be considered. And now in this emergency period, the Coronavirus Act is also important to consider, and its emergency code of practice is really an addendum to the 86 orders code of practice, and explains some of the wording in Schedule 10 to the Coronavirus Act, which is the part which relates to the 86 order, is quite difficult in my view. So the code of practice is a helpful, more accessible version of that that explains it a bit more clearly, I think. Okay. Again, I know you're already familiar with the 86 order, so this is to remind you of some of the key aspects of it. So it's focusing obviously on mental disorder, which is defined in Article 3.1. The 86 order as mental illness, mental handicap, and any other disorder or disability of mind. Just to sort of there is a bit more detail about what those terms mean. Some of the language in the 86 order is quite old and isn't now commonly used, but nonetheless. So mental illness means a state of mind which affects a person's thinking, perceiving, emotion or judgment to the extent that he requires. So it's gender specific, but obviously it applies to everyone. It's just of that time. He requires care or medical treatment in his own interests or the interests of other persons. Mental handicap means a state of arrested or incomplete development of mind, which includes significant impairment of intelligence and social functioning. Severe mental handicap and severe mental impairment are also further defined. So an important thing just to remind you of in terms of the definition of mental disorder under the 86 order is that Article 3.2 specifically excludes detention by reason only of personality disorder, promiscuity or other immoral conduct, sexual deviancy or dependence on alcohol or drugs. So it's just to alert you to that. So a person doesn't meet the mental disorder criterion if the view is that their difficulties are only personality disorder, for example, or dependence on alcohol or drugs. I think in practice it's relatively rare for a person to be experiencing either of those difficulties in isolation of other mental health problems, but it's just to alert you to those specific exclusions. Okay. So these then are the criteria for admission for assessment under the 86 order. These are set out in Article 4.2, which states that an application for assessment may be made in respect of a patient on the grounds that they're suffering from mental disorder of a nature or degree which warrants their detention in a hospital for assessment or for assessment followed by medical treatment, and failure to so detain them would create a substantial likelihood of serious physical harm to himself or to other persons. There are just a few things to highlight about both of those criteria. In the mental disorder criterion, it's important to note that it's not sufficient that the person is experiencing some form of mental disorder. It has to be of a nature or degree which warrants a detention in hospital. And in the risk criterion, it's important to note that it's not just any sort of risk to the person themselves or to other people. It has to be a substantial likelihood, so there has to be a real probability. And the harm that you're concerned about has to be serious physical harm to the person themselves or to other people and or to other people. Okay. The process then of admission for assessment under the 86 order. So in order for someone to be admitted under the 86 order, there has to be an application and a medical recommendation. So the application for admission for assessment can now be completed by people in 3 different roles. The first is the person's nearest relative, who would complete Form 1. And the nearest relative is specifically defined under the 86 order. We'll come back to that. So it's not up to the person to identify who they want to be the nearest relative, or for a relative to nominate themselves. The nearest relative is defined under the order, so it's not possible for the person to select that. They can, in theory, go to court and so on to change that, but in these assessment processes, it's very unlikely that that would have happened. The application can also be completed by an approved social worker, so that's someone who's completed the approved social work programme, and if that's the case, they would are approved by their trust, and if that's the case, they would complete Form 2, or now under the Coronavirus Act, a relevant social worker, and if it's a relevant social worker completing the application, they use the emergency Form 2, or they can modify an ordinary Form 2, but it's much easier, obviously, to use the format provided in the emergency code. And they also have to complete 2A, which is the relevant social worker statement. So the application is founded on and has to be accompanied by a medical recommendation, which is completed by a doctor on Form 3. Ideally, and it often is a GP, and again, preferably a doctor who knows the person, and if they don't previously know the person, you need to note why it hasn't been possible to get a doctor who does know the person. On arrival at the hospital, the person then is further assessed by a hospital doctor to decide whether admission is necessary and justified. So under the 86 order, they should be examined, assessed by the hospital doctor immediately on arrival. Under the Coronavirus Act, that's extended a little to within 12 hours, but nonetheless, obviously, it should be as soon as possible. As soon as after they arrive at hospital, they should be assessed by the doctor there. If they feel that the person should be admitted for assessment, the initial assessment period, as detailed under Article 9 of the 86 order, is for up to 7 days, and under the 86 order can be extended for another 7 days. So the assessment period is up to 14 days in total. but under the Coronavirus Act, for the period of this emergency, that extension can be up to 21 days. So the assessment period is now up to 28 days in total, while the Coronavirus Act is in place. If at the end of that 28-day assessment period continued detention is required, then the person can be detained under Article 12 of the 86 order for up to 6 months, then a further 6 months, and then for a year at a time. So the Coronavirus Act introduces this role of the relevant social worker as applicant, and it also increases some of the time limits for assessments. Under the 86 order, you as applicant would have to personally seen the person within 2 days. That's now extended to 5 days. That's also the case for the person who's completing the medical recommendation. And there are holding powers, which we'll come back to. That's if a person is already a voluntary inpatient in general hospital, or indeed in a psychiatric hospital or learning disability hospital. If they're a voluntary patient, and usually the situation is that they attempt to leave, or there's a concern about them leaving, and there's sufficient concern, obviously, that they might meet the criteria under the 86 order, and a doctor can complete Form 5, which can hold them under the 86 order for up to 48 hours, and the modification by the Coronavirus Act is that's extended to 120 hours, so for up to 5 days. And a nurse can complete Form 6, which would hold the person under the 86 order for 6 hours, and extended, modified by the Coronavirus Act for up to 12 hours. So both of those holding powers and others under the order, including the police holding powers, are to facilitate your assessment and the assessment of the medical practitioner. So these are the key modifications, just to run through those again under Schedule 10 of the Coronavirus Act. So an application for assessment can now be made by a relevant social worker, as well as an approved social worker, but it can only be made under paragraph 3 is the crucial bit about relevant social workers, paragraph 3 of Schedule 10 of the Coronavirus Act. It can only be made by a relevant social worker if you're of the opinion that an application should be made and that it is impractical or would involve undesirable delay for the application to be made by an approved social worker. So that has to be the situation, that it's not possible for an approved social worker to complete the application. When you're acting, you must also inform the person, and if it's practicable, their nearest relative, that the applicant is a relevant social worker, and why you're acting in that role. So it's essentially that it's not possible to involve an approved social worker. You have to have personally seen the person within 5 days. And in the emergency code, it allows that requirement in terms of personally seen can, in exceptional circumstances, be by alternative methods of communication. So that's allowing, and it specifically refers to it, that I guess really thinking about sort of infection control, that it might be using something like FaceTime or Skype or something like this. But regardless of what means you use, what methods you use of communication, you are in effect still personally seeing the person, and it has to be, the methods used have to be sufficient for you to conduct your assessment. So if it's a relevant social worker completing the application, they must also complete the statement, Form 2A, which is also in the emergency code. I would really encourage you to use the format of Statement 2A, because it's quite a complicated statement, and the form sets all this out for you. So the statement this is set out in Schedule 10 of the Coronavirus Act. In paragraph 3, it specifies that the statement has to include that the application is being made in reliance on this paragraph. In other words, paragraph 3 of Schedule 10 to the Coronavirus Act, that the social worker, that's yourself as relevant social worker, is of the opinion referred to in subparagraph 1. That's that basically that an ASW isn't available and that an application should be made. That you're registered in accordance with and has the experience required by this paragraph. That's that you are registered with NISC and that you have five years experience, at least 5 years experience, sorry, in the last 10. That you've informed the person who's being assessed that about your role and why you're there, and also that you've informed the person appearing to you to be the nearest relative, again, of your role and why you're acting as relevant social worker, and indeed that you also have to inform the person who's being assessed and the nearest relative of the outcome of your assessment. If you're not able to either identify or contact the nearest relative, you have to include reasons why it was not practical to do so. And you also, ideally, if you have been able to ascertain the views of the nearest relative and indeed the views of the person being assessed, you have to record those again on 2A. So it gives you a format for doing all that. Another thing just to note that the Coronavirus Act, it again modifies the period within which corrections can be made to your application. So currently, if you yourself or, for example, the nurse in charge in the ward the person is being admitted to, or indeed your sort of medical records people pick up a mistake on your forms, under the 86 order, you're allowed 14 days to correct a mistake like that. That's now extended to 28 days. So there's a bit more time if a mistake in the form is picked up at any stage, which would allow you to correct it rather than having to restart the process. Okay, this is the parts of the emergency code which refer to the relevant social worker role. And again, as you'll see, I think the language used in the emergency code is a wee bit more accessible, which is helpful, but it's really further explaining Schedule 10 to the Coronavirus Act. So in the emergency code, in paragraph 22, it specifies the 86 order requires an application for compulsory admission to hospital for assessment to be made by an approved social worker. In an emergency, applications can, in addition to approved social workers, be made by a relevant social worker if an approved social worker is not available. That's the key difference, really, that now that you can act as applicant, as long as you meet the criteria to be a relevant social worker. So that's that you're registered with NISC and that you have 5 years experience in the last 10, and it doesn't have to be continuous and so on. Okay. In order to act as applicant, you also must be of the opinion that it would be impractical or would involve undesirable delay to wait for an approved social worker to make the application. And this is, again, if you're making the application, you must use the emergency form 2. So that's provided in the emergency code of practice, where you can use an ordinary form 2 and change the sort of wording to clarify that it's a relevant social worker making the application, but it's obviously much easier to use the emergency form 2. All of these forms, it's just to make them more visible in a way, and in the notes should be printed on pink paper if you can. You should also inform the person, and where practicable, the nearest relative, that it's a relevant social worker rather than an approved social worker making the application, and why that is. In other words, that it hasn't been possible to involve an approved social worker. You have to attach a written statement to the emergency form 2, which the emergency code allows can take any form, but I would obviously really encourage you to use the format provided, because it's quite a complicated statement. So again, that's in the emergency code in Annex A, along with the emergency form 2. And again, the code just sets out the requirements for that statement that have already been detailed in Schedule 10 to the Act, but in maybe slightly more accessible language. And that language is from the code is in the statement, so that the application is being made in reliance on the emergency provisions of the Coronavirus Act, and specifically, as you now know, paragraph 3 of Schedule 10 to the Act, that you as the relevant social worker believes that an application should be made and that it would be impracticable or involve unreasonable delay to wait for an approved social worker. Let's see. That the relevant social worker is registered as a social worker and has at least 5 years experience in the last 10, that you've informed the person and if practicable the nearest relative, that's of your role and of the outcome of the assessment. And if the nearest relative has been informed what the views of the nearest relative are, and if you haven't been able to inform the nearest relative, why it's not been practicable to do so. Okay. In terms of who the nearest relative is, the 86 order sets out how you identify the nearest relative in Article 32. Helpfully, this is also included on the back of the Form 1, so it's useful to be available to you a set of all of the relevant forms. Form 1, which is the one which the nearest relative would complete if they were the applicant. Form 2, which is the ASW's application. The emergency Form 2, which is your own application, and Statement 2A. And also Form 3, the medical recommendation. It's really just in case somebody acting in one of those other roles doesn't have the form available to them. It's useful to have the sets of forms with you. It's useful to have Form 1 also for this reason, because it has this list on the back of it, which identifies how you determine who the person's nearest relative is. So essentially, it's somebody on one of the categories on this list. So the first person who appears. So if the person has a spouse or civil partner, then they're their nearest relative. If that's not the case, then it's and if they have a child, it's the child, and so on. If that's not the case, the parent, brother or sister, grandparent, grandchild, uncle or aunt, nephew or niece. If one of the people on that list is providing care for the person, then they're regarded as the nearest caring relative, and they jump to the top. So if the person has a caring relative, they are the nearest relative. If that's not the case, then it's just the first person in the first category that's relevant. If there are two people in the category, then it's the older or eldest. There are a few people excluded from acting as nearest relative. So nearest relative must be aged 18 unless it's the person's spouse. And the definition of spouse includes a person living with the person you're being assessed as their partner for 6 months. If they're no longer married, they're disregarded as the nearest relative, or indeed, if they reside outside the UK. If someone is living with the person not as their partner, but they've lived with them for ordinarily for 5 years, they can become the nearest relative. And if it's a child being assessed, the 86 order applies to all ages, in contrast to the Mental Capacity Act. But the 86 order applies to everyone. And so if it's a child that you're assessing, the nearest, and they're looked after, then the nearest relative is the trust. Okay. The next parts are just running through the key aspects of the role of the ASW under the 86 order and the role of the relevant social worker under the 86 order. And they're not dramatically different, as you'll see, but there are some things to note. So the role of the pre-social worker under the 86 order is to act as applicant for admission. In order to do that, they have to interview the person in a suitable manner. They have to consult the nearest relative, so they have to identify who the nearest relative is and consult them unless it's not reasonably practicable or would involve unreasonable delay. So case law has also established that not reasonably practicable can include whether it's appropriate to consult the nearest relative. So that's usually in a situation where you make a professional judgment that it would be harmful in some way to consult the nearest relative. That's usually if the person who's identified as the nearest relative has been abusive towards the person you're assessing. You need to have a good reason not to consult. If you are able to identify and consult the nearest relative, and in your discussion with them, they state that they don't agree that the person should be admitted to hospital under mental health law, if they object, in other words, then for those in the approved social work role, they have to involve a second ASW to conduct their assessment to determine whether they think that the person should be admitted or not. Then it's the ASW's role to ensure that the person is conveyed to hospital. So as you'll see, the relevant social worker role is very similar to that. The key thing is that they can also act as applicant for admission. They also have to interview the person in a suitable manner. As I mentioned, the emergency code allows for the possible use of alternative methods of communication. I guess that's mainly to protect you and other people from the possibility of infection, but you could also be thinking about situations where there might be the concern about safety for other reasons, but that should be in exceptional circumstances. The wording is slightly different around the nearest relative. You also have to identify who the nearest relative is, and in the relevant social worker role, inform them. That will obviously involve talking with them and trying to get their views about what's happening. So you're consulting them in a way, but it's slightly different because if the nearest relative objects, as a relevant social worker, you're not required to consult an ASW. That makes sense because the circumstances really in which you'll be acting as relevant social worker are that it hasn't been possible to involve one ASW, so it makes sense that you wouldn't be required to consult an ASW because they're not available. So it's just important to note if you're talking with the nearest relative and getting as much information as you can to inform your assessment, and as part of that you need to ask them their view of whether the person should be admitted or not, and they say they don't think they should. That then doesn't mean that you have to consult an ASW. You do though have to record the nearest relative's views on 2A, so do take a note of those. You then, as relevant social worker, have responsibility for conveying the person to hospital. You can delegate that. It's often the case, most commonly, to an ambulance crew, sometimes with the assistance of the police. But it's your responsibility to ensure that the person is conveyed to hospital and to follow them there and provide information to the hospital staff. And if necessary, make alternative arrangements. If the hospital doctor decides that the person doesn't require admission, then it's still your responsibility to make alternative arrangements to manage whatever the concerns that have been identified are. You might also be involved in other aspects of the 86 order. It's just to note those. I'm sure already familiar with these. If the nearest relative acts as applicant, then social worker has to complete a social circumstances report. If a person disagrees with their detention, or indeed if their nearest relative disagrees, that will be considered by the review tribunal. You might be asked to complete a report for the tribunal, and it can also involve if somebody doesn't have the capacity to make the relevant financial decisions. It might also involve working with the Office of Care and Protection. Okay, so just to reinforce these key parts of the 86 order, which you need to consider in your assessment, whether you're an ASW or a relevant social worker. The key criteria are the mental disorder criterion, which is that the person is experiencing mental disorder of a nature or degree which warrants their detention in a hospital, and their risk criterion, which is failure to so detain them would create a substantial likelihood of serious physical harm to themselves or to other persons. So the process to do that, we've tried to distill it, is that you have to And before your assessment, gather as much information as you possibly can to inform your assessment. You have to coordinate the assessment. That can be, first of all, identifying where the person is and whether you can access them. Talking with the medical practitioner, ideally arranging to be there at the same time. May also be coordinating with the ambulance service and the police service. You then have to interview the person in a suitable manner, consult and inform the nearest relative, discuss your assessment with the medical practitioner if that's possible. Sometimes that isn't possible, but ideally you would be discussing your assessment with the medical practitioner. You have to consider all of the possible options. You're always going for the least restrictive option. So sometimes the least restrictive option will be compulsory admission to hospital, but you should be having a regard to what is the least restrictive option that is sufficiently safe for the person and for others. If that isn't hospital admission, you need to be thinking what alternative arrangements can you put in place to try and manage the identified risks and support the person and their carers. If it is hospital admission, then it's, as I've said, your responsibility to arrange safe conveyance. Just to note in terms of those options, so it's compulsory admission, you should also bear in mind that voluntary admission is a possibility if the person is willing to consider that. That they also, another option is that they remain in the community with those additional arrangements. It may also be that the person doesn't fulfill the criteria for admission under the 86 order, and that they have the capacity to refuse other forms of intervention. So sometimes the outcome is that the person remains in the community with no additional support in place. And if that's the case, do think of what other things might be useful to try and manage the identified risk. That might be just making sure that everybody involved has additional information about who to contact, or it might be asking the relevant team to get back in touch to offer support again. At the end of your assessment process, regardless of the outcome, you should be completing your applicant's report, and there's a set format for that, which is the Mental Health Order B format, which you have in the resources, and it's worth having a read through that. It's a good structure for all the things that you should be considering in your assessment, and all of this is informed by the risk assessment, the regional risk assessment guidance. Okay. In terms of the risk criterion, there are a few additional sources of information to help you with what you should be considering to determine whether failure to detain the person would create a substantial likelihood of serious physical harm. And the concern is about risk to the person themselves. Article 2.4 of the 86 order says that you should, that regards shall be had only to evidence that the person has inflicted or threatened or attempted to inflict serious physical harm on themselves, or that their judgment is so affected that they are or would be unable to protect themselves against serious physical harm, and that reasonable provision for the protection is not available in the community. And if the concern is about substantial likelihood of serious physical harm to others, regard shall be had only to evidence that the person has behaved violently towards other people, or that they've so behaved that other people were placed in reasonable fear of serious physical harm to themselves. Okay, so it's just emphasizing that it is a substantial likelihood and that it's serious physical harm. In terms of trying to assess risk, the regional risk assessment guidance is helpful. It really emphasizes the importance. I mean, you're all experienced practitioners, you're familiar with these issues, but it's just to reinforce the importance of asking the direct questions. So as part of the process, you'll be really wanting to identify what are the concerns, what are the risks that have been identified, and then exploring those with the person themselves and the nearest relative and anybody else who you think might be useful in terms of providing information to inform your assessment. You need to be thinking about sort of the wider demographic factors that might indicate at the population level increased concern, but these won't determine your risk assessment for you. So people who may be in many of these categories won't be presenting a substantial likelihood, and people who aren't in any of them may well be. So it's an individual assessment, but do be aware of some of the issues that might increase your concern. Thinking about risk to the person themselves from self-harm and or suicidal behaviour. You need to explore with the person if they're having suicidal thoughts, and if they've had made any plans about those. It's obviously it would heighten your concern if a person is saying that they are thinking of ending their own lives and they have a specific plan about how they're going to do that. It can also be increase your concern if the person has a history of suicide attempts and or of self-harm. If they're preoccupied by suicide, if there's a family history of suicide or of recent bereavement, and also you should check out if a person is saying that they're intending to end their own life, if they have thought about how they're going to do that. So in other words, if they have a plan, and also if it would be very concerning indeed if they'd already sort of done something to secure means. So stockpiled medication, for example, to take an overdose, or bought a rope, for example, or have access to a weapon, and so on. Risk of substantial physical harm can also be through self-neglect. That's, I suppose, most can be through a number of different things. One can be if a person has stopped eating and or drinking. That can be associated with a number of things, maybe delusional beliefs that they're being poisoned, something like that. It can also be, I guess this is more commonly people who might be experiencing some form of dementia, that there can be a risk of wandering, and so as part of that, there could be a substantial likelihood of serious physical harm or falling, or them not sort of protecting themselves as sufficiently at home or indeed outside the home. In terms of risk to others, that's mainly going to be through, and again, remember it has to be serious physical harm. It's going to be mainly through sort of violence. And so you'd be concerned if there is a history of violence towards anybody, and also if they're talking of or have a specific plan to harm others, especially if that's a particular person. Again, the parallel to having a plan to seriously harm or kill themselves. Also, if they're displaying a high level of anger, hostility, or threatening behaviour during your assessment, or if someone is reporting that to be the case. Also, if they have a history of owning, carrying, or using weapons, or a history of property, criminal damage, including arson, and also if they have a history of sexual assault. So, other factors to consider in your risk assessment are around if the person has been or indeed currently using alcohol or other drugs. If there are other issues that you need to consider in terms of if the person has responsibility for children and or others, you need to think about really alternative arrangements that might be needed to look after other people. If the person has physical impairment in some way, that might be something like if a person has been experiencing long-term pain, or indeed if they have a physical health problem that they're particularly concerned about, it might increase the risk of them thinking about ending their own life and so on. So those are other things to check out. If they have a history of dissocial and offending behaviour, it might increase your concerns about risk to others. You also need to think about the potential of the person disengaging. That is often around the consideration of whether you're going for compulsory or voluntary admission to hospital. Sometimes you can come to the view that the person might be agreeing to what you're proposing, just really essentially to make you go away. And if that's the case, it may be necessary to proceed with compulsory admission, even if the person is saying that they might consider voluntary admission. You also obviously need to be checking out as much information as you can about their history of mental health problems and their current mental health, their relationships with others, and any other indicators of risk. I suppose just at the minute there might be heightened concerns for people around things like obviously infection and sort of the health of others and their own health, but also around the money, about jobs and the future and how things might be different. So there can be other stressors at the minute which might be important to check out. As part of your assessment of risk, you also need to be trying to identify what protective factors there might be. So sometimes people can identify what might be a very concerning level of risk around the possibility of, especially them ending their own life, but they may say that there are things which would prevent that happening. It might be particular religious belief or the awareness of the potential impact on others, or that they have children or something like that. There may be some reason which they were saying I may be feeling having these feelings and thoughts, but they may be able to assure you that they wouldn't act on those. Obviously, if a person is unwell, they may have less control over that, but nonetheless, you should be checking out protective factors. Again, regardless of the outcome of your assessment, you need to be thinking about how you're managing the risks that you've identified. Okay. In all these processes, you need to be thinking about the human rights issues involved. In terms of the articles under the European Convention, which are part of domestic law through the Human Rights Act, the main aspect of the human rights considerations really for the 86 order are that you're trying to protect people's Article 2 right to life. So that may be the person themselves' right to life if you're concerned about risk of harm to them, and or the sort of right to life of others if you're concerned about the person possibly harming others. There are other considerations in there though. Certainly in terms of if you're trying to protect a person's Article 2 right to life, that may justify the infringements that would be involved in compulsory admission to the person's Article 5 right to liberty, and would also interfere with their Article 8 rights to privacy and family life. In terms of the process, you also need to be attending to people's Article 3 right not to experience inhumane and degrading treatment. So that's making sure that if some form of force is necessary, it rarely is, but it can be in some circumstances necessary for the person to be physically forced to go into hospital, that's done in as safe and humane as a way as possible. And their Article 6 right to a fair trial is also relevant just in terms of making sure that you're providing the person with as much information as you possibly can about what's happening and about the decision-making processes involved, so that you really do have to involve the person and their carers, particularly their nearest relative, throughout if practicable. And also in your report, you need to detail your decision-making process, really, that you considered less restrictive alternatives and why it wasn't possible to go with those. Okay. We do need to, the regional format for your report will prompt you to talk about these considerations, but you do need to discuss them in your report. There's an interesting aspect of the 86 order, which is Article 10. So it sometimes comes up even in the assessment process that a person is, or indeed that their family is worried about the possible future implications of them being detained under mental health law. An interesting and progressive aspect of the 86 Act was that Article 10 means that if the person is admitted for assessment for this assessment period, which is now extended from a maximum of up to 14 days to a maximum of up to 28 days. So that initial period of assessment of 7 days now can be plus a further 21 days. And they aren't further detained for treatment for the 6 month period. So if they're just admitted under the 86 order for that admission period, and then they're either regraded to being a voluntary patient, or they're discharged from hospital, they don't have to declare that as being detained under mental health law, unless in judicial proceedings. So if a judge asks them, but it's never really been fully tested how far that protection extends, but it can be useful to try and reassure people about that, just in case they're worried about the implications for, tends to be concerns around immigration or possible impact on trying to get a job in the future, or indeed in terms of trying to get insurance and that sort of thing. Okay. A number of other, we've mentioned a couple of the emergency holding powers in terms of when a person's already a voluntary inpatient in a hospital. There's the doctor's holding power, which is now up to 120 hours, and the nurse's holding power, which is up to 12 hours. The police also have emergency powers under the 86 order. If they encounter someone in a public place, they can use Article 130 of the 86 order. Or if a person is in premises, they can use a warrant under Article 129 of the 86 order to enter, search for and remove the person. So the police powers are both, whether it's a public place or premises, they're both to enable the person to be taken to a place of safety, which is usually the accident emergency department of a hospital or a police station, and held there for up to 48 hours. So the purpose of all of these holding powers, the police powers and the doctor's holding power and the nurse's holding power, are all to enable your assessment and assessment by the medical practitioner. So they shouldn't be used as a form of intervention in themselves. They're really just to enable your assessment. Just to mention a few other things which are of less direct relevance to your role as relevant social worker, but just to remind you of them. Under the 86 order, there's still a possibility of guardianship. So that can be community powers to require a person to reside in a specific place, or to attend places and times for treatment, occupation, education or training, and or to require that they allow access. It's usually by the relevant team involved. So just to reinforce again the key aspects of the law and guidance, the key criteria are that the person is suffering from mental disorder of a nature or degree which warrants detention in hospital, and failure to so detain them would create a substantial likelihood of serious physical harm to themselves or to other persons. If you feel those criteria are met, the medical practitioner also needs to be obviously satisfied of that, and they complete Form 3. And then if you're also satisfied that the criteria are met, you can complete the application founded on the medical recommendation, which is in the emergency Form 2 and accompanied by Statement 2A. Okay, just again, a few other things to mention about the order. The 86 order overrides the common law position in terms of consent. So when a person is detained under the 86 order, it's possible for them to be treated even if they have capacity to refuse. It's part of the rationale for the Capacity Act, which eventually will replace the 86 order, but nonetheless this is still the case until the Act is fully implemented. Obviously it should, this will be usually the healthcare staff involved. They should still be trying to obtain consent if at all possible, but the order allows them to proceed without consent if the person is detained. There are a couple of additional safeguards for specific forms of intervention, ECT and psychosurgery. So there are additional requirements around second opinion and or consent for those, which are further detailed in the law. Also to mention the role of the review tribunal. There are, just to mention, the Coronavirus Act also does make some modifications to the Mental Capacity Act. That's in Schedule 11, which is on page 124 of the Act, So if you're also involved in, especially the operation of trust panels, it's important to have a look at that. But under the 86 order, if a person disagrees with your decision that they should be admitted, they can appeal to the review tribunal. It's three members, a legal member, a medical member, and a lay member. It's chaired by the legal person. Should be encouraging the person to access legal representation. And the tribunal is essentially considering what you have considered, whether the criteria under the order are met, and if the tribunal thinks that they are not, then they have a duty to discharge the person. If the person has been detained for 2 years, they're automatically referred by the trust to the tribunal for them to consider the detention. Also detailed in the 86 order is the sort of oversight function of what's referred to in the 86 order as the Mental Health Commission. It's no longer a separate body. It's now within the functions of the Regulation Quality Improvement Authority. Again, this can be a useful thing to alert the person to. In addition to their ability to appeal against their detention, they can also get in touch with RQIA if they have any concerns about their care and treatment. And also, I mean, again, you can remind people of their option to complain to the trust and so on. I realise they would probably be considering complaining or contacting RQA about you, but it's nonetheless important in these circumstances to remind people of their rights and to make sure that they have, in a situation which involves a considerable power imbalance, really, that they still have your respect and they still have some power in that situation. Okay. Also under the 86 order, there are a range of powers for the courts. Again, this is of less direct relevance to you in the relevant social work role, but just to mention them very quickly, so that the courts can remand a person to hospital for a report on their mental condition or remand them to hospital for treatment. If they've been convicted of an offence, the court can order them to hospital, and if it's a very, very serious offence, they can restrict their discharge from hospital. And a bit more recently, the sort of 96 criminal justice order introduced treatment as an additional requirement of a probation order, and also inserted supervision and treatment orders into the 86 order. So again, as alternatives for those involved in the criminal justice system. Just to reinforce the sort of potential overlap with the Capacity Act, so if the mental health order, the 86 order applies, then it should be used. But there might be situations where you are considering intervention, the criteria under the 86 order aren't met, but you may feel that intervention is still necessary. And as you know, if that intervention amounts to deprivation of liberty, then you would have to be considering whether the Capacity Act applies. In other words, the person lacks the capacity to make the relevant decision, and what you're proposing, the intervention which amounts to deprivation of liberty, is in their best interest, then you would have to be working under the Capacity Act. If the intervention doesn't amount to deprivation of liberty, the common law might still be relevant. Again, you would still have to be satisfied to have a reasonable belief that the person lacks the relevant capacity and the proposed intervention is in their best interests. Regardless, you should attend to the general principles. The capacity should be presumed, and it's up to you really to establish whether the person lacks capacity or not. Capacity is decision and time specific, and the functional test involves that process of trying to work out if the person understands, if they can use, weigh and appreciate the relevant information, and if they can communicate their decision and retain the relevant information. If there's concern about a person's ability to make financial decisions, again, there are aspects of the law which are relevant. The Health and Personal Social Services Order from 1972, Article 38, enables property to be protected. As we'll talk about in the assessment process, you also have responsibilities just to make sure that a person's property, if they're being admitted to hospital, is secured. In terms of financial decision making, though, in the 86 order under Article 116, enables trust to hold up to 20 grand for people who are in their hospital care and accommodation. Might also be thinking about whether it might be relevant for an appointee to be put in place in respect of a person's welfare benefits, and consider any sort of other arrangements that are in place, for example, a controller, a person's financial affairs, or if the enduring power of attorney is in place. Under sort of Article 107 of the 86 order, the Trust has to notify the Office of Care and Protection where any person within its area is incapable of managing property and affairs, and arrangements, so other arrangements like enduring power of attorney have not been made. So, in terms of the role of the Office of Care and Protection, really it's to manage a person's financial affairs, and they can do everything really that would be necessary to do that. Okay, so just come to the end of part one, this sort of overview of the relevant law and guidance. And just to remind you that you have available to you the 86 order itself and the 86 orders code of practice, the relevant forums under the order, regional risk assessment guidance and some of the tools associated with that, the Coronavirus Act and its explanatory notes, and crucially the emergency code of practice, which contains a really clear explanation of your role as relevant social worker, and the emergency form 2 that you would complete if you're acting as applicant, and the form 2A, which is the statement you would complete to accompany the emergency form 2. Okay, let me see. Okay, let me see. I'm just going to pause the recording for a minute, and we can maybe have a bit of a break.
I'm just going to share my screen. So is that all working for everybody?
Yeah.
Now, it's gone up to full size screen, which I wasn't quite expecting, but there we go. Okay. If you have any questions, just button ask Gavin. If you want to say anything, just do the same thing, if that's okay. Same format as before. So this is the second section. So it's about the assessment process, but hopefully it'll be a bit like a practical guide run through of it as well. So you need to keep handy, I suppose, the key and guidelines. There's a couple of flow charts and stuff I think that we referenced at the end of this. They're quite helpful if you think in those kinds of terms. The RQIA guidance about the prescribed forms is really, really helpful for you, especially for the forms 1, 2, and 3. And then we'll be talking to you specifically about the emergency 2. The ASW report guidance and the ASW report, do you all know what we mean by that? So you know the MHOB report that you'll have probably seen in your own work as well. It's a fairly well structured report, but that's pretty much like a checklist of the running order of things that need to get done. So you'll want to have a look at that, and if you want any more chat about that, come back to me another day and we can go through that, I suppose, in a bit more detail just among ourselves. The regional interagency protocol is mostly to do with conveyance risk assessment and stuff like that. So we'll talk a wee bit about that throughout this session as well. So say if you've any questions, just button and ask about it. What we want you to get out of this is basically to develop a bit more knowledge about the knowledge and skills that you'll need to undertake the assessment, but also to start thinking a bit more practically then about what are the criteria for the compulsory admission for somebody to hospital, and then the actual process of doing that. The approved social worker's role within the assessment process is just crucial, and you'll be mirroring that role pretty much exactly the same, with a couple of changes to it, mostly to do with the nearest relative objections. And then other factors that you'll want to consider in the assessment process as well. Now, we'll take a brief break after this session, and then we'll look at the applied examples as well, just to give you an idea of how that works through. Again, not surprisingly, it all hinges, if you like, on the mental health order itself. There's something called the guide, and you'll hear loads of ASWs talking about the guide, which when they're there is the guide to the mental health order, and the code is what we're talking about when we're referring to the 1992 Code of Practice. All of these have been provided in your packs as well. The Mental Capacity Northern Ireland Act has some implications for us, particularly if we're not going to be detaining the patient, and we're maybe thinking of doing what we call an alternative to admission. So again, we'll think about that, particularly in one of the case studies. Common law then, again, some of that still applies to us, particularly if we're trying to gain access to people, or if we're thinking about how we're going to respond. But the main bit is about the reasonable belief that you hold, and why do you hold that reasonable belief, and also that you're acting in the patient's best interests. So again, we'll think about that as we go through each of these pieces. Human Rights Act, you'll know that quite well, but also we'll apply those particularly around thinking about engaging the person's right to liberty. Coronavirus Act obviously impacts, because that's why you folks are doing this, and the Emergency Code of Practice, which we've already talked about earlier on. So the principles of this are really kind of, again, the social work value stuff, that even though we're working with somebody who is suffering from a mental disorder, we still want to be making sure that we treat them with dignity and respect, and that we're considering as much about their individual qualities and background as we possibly can, to make sure that the decisions that are taken are as close to what we can do that would support their unique situation, but also show them respect as well. And to take all of their needs into account, not just the kind of the health and safety stuff, but that we look at their psychological needs and care and treatment and so on as well. Because we want to make sure that the person receives the necessary care and treatment in a way that engages their human rights at as low a level as possible, and that we're not just wheeling in there to segregate somebody just because of safety concerns alone. The other bit that you want to do is be mindful that whatever form of constraint or control that we put the person under, or maybe put them under, particularly under the order, that they're released from that at the earliest opportunity. And people, you'll hear them talking about people being regraded after being maybe held and detained in hospital. That's what they're talking about there. And also been treated in a way that promotes their self-determination. So you'll have, over the last few years, you'll have heard lots of people talking about wellness recovery action plans and so on. And that's really fundamentally about trying to engage that person in planning for their care, but also re-engaging them back into those recovery plans as early as possible if they happen to have been detained as well. And sometimes people will have written things into their wellness recovery action plans about, I've been detained before, if this is happening to me, think about this, or get so-and-so to engage with me as part of this conversation. So, and it's all about trying to make sure that we follow the procedure, but that we do it in a just and supportive manner, or as supportive a manner for the patient as we possibly can. So where do we start with this? Well, I suppose for all assessments, we're wanting to think about, well, let's have some stuff gathered up together. So it's always a good idea to have the order, the code, and in your case, the emergency code in an accessible format or somewhere that you can make reasonable reference to it. It's also going to be, I think, really helpful to you and the other people around you if you get a wee set of the forms available as well. So Form 1's really handy to have because, as Gavin said earlier, on the back of it, there is a list of the the hierarchy of who the nearest relative can be. So just in case you forget that or whatever, Form 1, having it there available, really handy as a reminder for that. But it's also very handy that just in case the nearest relative decides that they do want to be the applicant, well, then you have the form available to allow them to do that. Form 2, you'll not be using it, but it's good for your own reference to have it there. But also then the emergency 2, which is the one that you will be filling out if you're going to be applying for the person to be taken to the hospital and admitted as a formal patient. The 2A's is makes your life simpler if you have that handy, because that complicated set of statements that you need to say about, I'm doing this because an ASW is not available and so on, it's emergency, all of that set out for you, along with a free narrative space for you to write.
James, do we have those? Do we have a set of those forms in the information you sent us?
Yeah, they're in the back of the code of practice, the emergency code of practice. But if you want, I'll separate them out as separate files, and then you'll find, and I'll put the 1, the 2, and all of that into a wee separate pack for you.
That would be brilliant. Thank you.
And the other place you can pick them up is off my SharePoint page, because the forms are already there. So any email I've sent to you in the last few days may have an ASW training button on the bottom of it as part of my signature. Just click there and it'll bring you to our Trust SharePoint page for that.
Yes, I'm in there.
Yeah, so anybody else listening outside of our Trust, the simplest place to find the emergency 2 and the 2A is towards the back of the emergency code of practice. And you can copy and paste those into separate documents if you want to set up your own forms. Best to handwrite most of the detail of that, but we'll not go into all the rationale for that. But there are case law reasons as to why you want to handwrite the majority of the form. Okay, you'll want to also identify who the trust contacts are for you to provide advice. So in most trusts, you'll have a lead ASW and you'll also have a lead ASW trainer. And in our trust, we will also be having now on a rota basis an individual who's available for you on any given day to provide you with support as relevant social workers. And that rota is going to be sent out to you on a weekly basis. And it may then turn out to be that it will always be this person on a Monday, this person on a Tuesday, and so on. So there's a few folks like that as well. And that'll include the lead ASW and myself as well. Okay. There's other people that you'll need to think about in terms of getting access to beds and stuff. That tends to be bed managers and people like that. So certainly within the Bluestone unit, there's a bleep number. We can make sure that you have access to that. And the ambulance phone numbers as well. If you don't already have those, really helpful to get it. Now, it's usually the GP that would trigger the request for the ambulance, but quite often the GP will not be available for the whole duration of this. They'll do their part and then quite rightly move on. So it's always good to get the reference number of the call that they made to the ambulance service, just so that if you're updating that risk assessment or maybe seeking a change to the timeline for some reason, you can then go, here's the reference number, and I'll update the call much quicker. Same for the police as well. They will be able to give you a reference number if you're putting them on notice that you're doing this and you may need support or whatever at a later stage. So again, have all of these numbers either in your phone or in a book that's handy and secure for you to work with. And then there's also maybe other numbers that you'll have to do with emergency accommodation, contact children's services, and maybe even some of the support numbers for access to dog pounds or somewhere like that for securing animals and stuff, because we may have to do that as part of this role, and particularly if the person lives on their own. In our trust, we've also, as a last resort, used the ARC down, isn't it the ARC you call it, down towards Newry direction?
Yeah.
facility. So if there's nowhere else, we've at least one occasion I've used that as well, but you tend to want to use somewhere closer to where the patient actually lives. So who's going to be contacting you? Well, basically these folks are going to be in one of three places. They're either going to be in a private dwelling or on premises that are private, or they're going to be found in a public place, or they're going to be already in hospital. So let's deal with the folks who are found in a public place. If they're found in a public place and the police feel that they need to be assessed by an ASW, they can remove them under Article 130 from that public place to a place of safety. And for the Trust's point of view, that's always going to be the ED, although it's possible to bring the person to the police station, and it's also possible to bring them to somebody else's house with the consent of the owner of the house. But that's kind of a police matter, and that will trigger the request for an assessment. The other option then at the bottom of that screen, we talk about people who are already in hospital, and some folks become more unwell even after they've gone in, and maybe they've gone in as a voluntary patient. Their situation has continued to deteriorate, and they're maybe expressing a desire to leave or attempting to leave, and the doctors can say, well, look, we'll talk about putting a Form 5 on somebody is the language you'll hear people using. What they mean by that is somebody will sign, a medic will sign a Form 5, and that will normally hold them for 48 hours to allow an ASW or yourself to come and expedite the assessment. That Form 5 now can last for up to 5 days, which is 120 hours. And the range of doctors who can sign that is slightly adjusted as well. But from your point of view, it's to give you the time to do the assessment. So contacting the nearest relative, doing the background checks, getting there yourself, all of that. And a nurse can sign a Form 6, which also holds the patient. Very rare for that to have been done. It's normally a doctor doing the Form 5, but under these circumstances, we might see some changes on that. So you need to be clear whether it's a Form 5 or Form 6 and who is signing that kind of crack. The most common place for people to be found, if they're not already in hospital, is usually what we call in the community. So that could be in their own home or in somebody else's home or in the emergency department or the police station. All of those facilities and places would be seen as community settings and would all then follow the normal pathway. So you'll not get a Form 5 being signed by a patient who's in the emergency department. They're not technically a patient of the hospital. It's a community facility. So that's kind of the areas that you'll be mostly seeing. One wee anomaly for you would be that if somebody's in a building, private property or whatever, and whoever owns the property or is responsible for access to it is denying you access to the property, we can look for a warrant under Article 129 to allow the police and the GP to go in and, if necessary, by force for the police to then remove that person to a place of safety. But we'll maybe consider that a wee bit more detail when we look at an applied example. They're time consuming, they're difficult to get, and most of us, I think most trusts would find that they use a small number of these in a year. They're not that commonly used. Okay, so the first phase of your assessment is obviously going to be gathering the information. So this is the key aspects bit. So that gives you the running order of what you need to do. Gather lots of information, coordinate the assessment. At the moment, obviously following the relevant infection control guidance. So if you're on rota or you're expected to be used, the day before you need the stuff, go to the Acorns and you'll be able, if you're in the Southern Trust, and you'll be able to pick up the PPE equipment that you need. You will need to interview the person in a suitable manner. You will need to consult or inform the nearest relative, and we'll talk more about that. You're going to discuss with the medic, now that's the medic who's making the recommendation to you, normally a GP. and you'll need to consider what other options are available to you. And if you're going to admit the patient, then it's your responsibility to sort out the conveyance and then communicate all of that information to the relevant people before, during, and after the admission process, including where you've decided maybe not to admit. It's up to you to follow up with the alternative plan as well. And then obviously complete all the relevant recording. So that's the formal forms. The crucial one is that MHOB form, and within our trust, the standard would be that you'll actually complete that MHOB form on the day of admission, and you'll be given space within the beehive area at the hospital to complete that. But for anybody else watching, the standard would normally be that that's completed within an MHOA completed same day and MHOB completed within 5 working days of the assessment. But the Southern Trust, we're expecting you guys to do the MHOB on the same day. So who has to be involved with the assessment for compulsory admission? There are a small number of people really. It's actually the medical practitioner who does the Form 3. Somebody has to make the application based on that medical assessment, and that's usually, well, can only be the nearest relative or the approved social worker, or in your case, a relevant social worker. So key ones: medical practitioner, the patient's nearest relative, and yourself. They're the key people through this process. So who should make the medical recommendation? It's normally a GP, and they have to have seen the patient normally within 2 days. That's now been extended to a 5-day period within which they should have seen the patient before signing the form. And if it's at all possible, we would be looking for that to be done by their own GP. Now, that's become increasingly difficult to get. Certainly in 1986, it would have been very common for the patient's GP to know them really well. Now that's not so much the case, so there are other arrangements in place for a GP who would hopefully have previous acquaintance through the practice or through some other arrangement to provide that. If there's an exceptional urgent necessity, then somebody from the receiving hospital a medical practitioner there can make the medical recommendation. So for example, if the patient was in the emergency department, then some medical member of staff from the Bluestone unit could come over as part of the site liaison service to consider making that medical recommendation. But if they make the medical recommendation, they cannot be the doctor who then admits the patient into the Bluestone unit. So whoever signs the 3 cannot sign the 7, and as far as I know, that hasn't changed. So watch out for that a wee bit later on. And then if the application's made, it's the role of the person making the medical recommendation to secure the bed and then provide you with the details of that. You'll need that information for your form, so that's why that needs to be known before you're able to complete the emergency 2 and the 2A as well. So then you would be what we would call the applicant. So the medical recommendation comes to you, you then apply for the person to be admitted to the hospital, and your responsibility is that you shall interview the patient in a suitable manner to satisfy yourself that detention is actually required and proportionate and all of that. And the codes of practice sets out your responsibilities about how you would do that. 2.14, for example, says that you need to be satisfied that it's necessary and proper for the application to be made, that you need to interview the patient yourself. And at the start of that interview, you need to be clear and with candour, I suppose, as well, about who all is present, everybody's roles within that, and explain in clear terms to the person the purpose of the visit, and make sure that other people have done the same thing, other professionals are involved. And under the emergency code, it does allow for that communication with the patient to be by alternative methods. So normally that wouldn't be like through a doorway, but I mean, you would normally want face-to-face, but it's only in exceptional circumstances we could maybe use the likes of this technology that we are using to deliver this. So again, as we outlined earlier, 2 key points. The person must have a mental disorder of a nature and degree that warrants their detention. And that's really what the medical person is saying to you. This is their belief that the person has this. And then there's the failure to so detain would create a substantial likelihood of serious physical harm to himself or others. You will get a lot of people trying to push the buttons by saying, look, this person's causing an awful lot of emotional distress to their carers, to others, or whatever. And whilst that's interesting, and we must bear that in mind, in terms of detention, it has to fall back to what's the serious physical risk to self or to others. And then in doing that, you're going to be gathering the information to coordinate the assessment and looking at the least restrictive way of doing that. You must discuss the whole thing with the medics. So even if they've left the Form 3 and cleared off, you must contact them. You must discuss with them what they have recorded and left for you in terms of the Form 3. And then the options available to you are compulsory admission, voluntary admission into the psychiatric hospitals, or to stay in the community with the additional supports, or to remain in the community with no additional supports. But again, I would be of the view that if you're leaving a situation with no additional formal supports, you should at least be leaving contact phone numbers, other resources that individual or their family or whoever could make use of if things start to change. And then you'll obviously complete the regionally agreed report format as well, using the guidance. And that's the risk assessment. So what is a substantial likelihood of risk to self or others? So basically you're looking at the patient has already inflicted or threatened to inflict or attempted to inflict that serious harm on themselves or other people. You're going to be looking at how impaired their judgment might be, and whether or not they're able to protect themselves from other reasonably predictable risks that are around them. So that could include, for example, that they're behaving in a way that is attracting negative attention from the local community. And then as a result of that, they could get assaulted or something like that because of their behaviours, and they're not able to protect themselves from that. Those sorts of things could factor into that as well. And again, the person has already been violent towards others. Yeah, and other persons placed in reasonable fear of being seriously physically harmed. So what makes you think that's a reasonable fear? It's not just that, oh, I'm gonna do whatever. Is there a reasonable fear that lies behind that? So in doing the assessment, then it's good practice to for the professionals involved in the application to be present at the same time. So it's really, really helpful if you and the GP can work together so that you're both in the room at the same time to do that assessment. But are there other people that you're going to need to help you with it? So for example, does the person use specialist communication skills, or do you need an interpreter there? Are there other people that are going to be supportive in terms of gaining a good understanding from the patient about their perception about what's going on? Now, it says there you normally wouldn't do that through a closed door or a window, but there are exceptions to that. So you might want to do part of the assessment if the person's not letting you in. You might want to do part of it through the door, and then as they settle with you and more comfortable with you, then go into the room. But your own safety is important in all of this as well. But also gaining access to the person. If other people are blocking access to the person, there are powers under Article 129 to gain access. Or if they're simply barricading their front door and not letting you in, you can look at that as well. Pace. police and criminal evidence, give powers to the police to gain access as well if you think there's a risk to life and limb, and the police will discuss why you hold that belief with you, and then take action if needed. Other things you might want to think about as well is how suitable is it to interview this patient at this point in time if they are under the influence of sedation, alcohol or drugs, or a mix of these. And you might decide that it's actually wiser, if it's safe to do so, to come back later, or do they need to go to the ED first for that treatment and then do the ASW assessment later after the effects of those things are less either life-threatening or less impacting on the assessment itself. The other person that you should be able to get good information from would be the nearest relative. And that's because the view in the law would be that the nearest relative has the patient's best interests at heart. It's not always the case, so you need to be mindful of that. But basically what you're wanting to know is, what does the nearest relative think about the person's presentation? What do they think the patient needs? And if you're thinking about, well, detention for hospital is an option here, what does that nearest relative think about that as an option? And are they objecting or not? Now, normally, if the nearest relative objects, we would be looking for a second ASW, but in your case, you'll be informing the relative of the decision of your assessment outcome under the emergency powers, but normally speaking, we would be looking to engage a second ASW, and we will be looking to see, consult broadly around then the other relevant circumstances as well. So if you do know that another team has been involved, like CAMS for young people, or support and recovery team, or home treatment team has been involved, really important that you consult with them as well as part of that broader consultation piece. And obviously consult the doctor who's in attendance, either face-to-face or if they've already left, over the phone. The emergency code of practice then, as I said just a minute ago, that if you're deciding that if it's reasonably practicable to consult the nearest relative, that you need to do that, but that you're informing them then of the outcome of your assessment. And when you're, because you're making this in the absence of an approved social worker being available. If you're thinking, well, I'm not quite sure about this, are there other alternatives to this? Again, the MHOB will prompt you for this, because it'll actually ask you about what alternatives you've considered. So it's really important that you show some evidence of what alternatives you've looked at. So good sources would always be home treatment and crisis response, to engage with them. Also thinking about the family and what other supports they're able to be putting in place. If there's other services, home help services that maybe could be secured to go in, domiciliary care services as well. So have a reasonable consideration of that, but bear in mind, if it's a particularly dangerous or risky situation, you don't want to be spending all day researching alternatives when you know that actually you have that it's timely to be getting the person towards the hospital. So you have to balance those sorts of things out as well. We can provide a fair wee bit of support under the Health and Personal Social Services Orders and also the Chronically Sick and Disabled Persons Act. But there's also maybe a wellness recovery action plan in place that you'll be wanting to think, is that plan now robust enough to support the person if we don't bring them into the hospital? Where people disagree as well, really important that you consider why people are disagreeing. Some people will, so for example, the nearest relative may well disagree with you because they think to agree with you could cause difficulties for their relationship. I've seen that happen before. So you need to be thinking about why is that happening. As there's a disagreement between you and the doctor. So let's say you've done a joint assessment and the doctor's saying, I'm not sure that they meet the criteria about nature and degree, and you're wanting to have a discussion with them about that. If they don't sign the Form 3, well, then you can't progress with the detention, but you need to be understand clearly why they're not willing to do that. The other option would be that they do sign the Form 3, and you're actually thinking, well, I'm not so sure that I'm in a position to sign the emergency 2. Again, have that discussion with them about why is it that you're feeling detention at this particular point in time is not the best way forward, because there's an alternative available, and you need to be putting the alternative in place. So you need to have a named professional who's going to oversee that plan. It might be you initially, but you should also be making sure that copies of it are shared with the relevant people as well, and be mindful of the need to protect confidentiality and so on as well. So any comments from anybody about any of those bits?
See, James, the nearest relative, if you aren't able to get in contact with them, do you have a responsibility to follow that up the next day, or where's the time?
Yeah, so we will come to that, Hazel, but certainly in this early stage, you need to be thinking about words like unreasonable delay, not practicable, and so on. So, so for example, if somebody's in their own house and you're doing this assessment, the time frame is much more difficult, it's tighter. Whereas if somebody's, as we call, held on a Form 5, that Form 5 gives you 48 hours to find and locate and work and to identify the nearest relative. So your defence about not reasonably practicable is a little bit more difficult there than it would be out in the patient's own home. So all of those factors come into play, but if it's not reasonably practicable to get them right now, and you must detain them right now, well then yes, you still have a legal obligation to come back to that person and if you can identify who they are, to go back to them at a later stage.
Yep, and just to reinforce the modification under the Coronavirus Act, it would then give you up to 120 hours in the Form 5, but yeah, right.
Yeah, and one of the things that I've noticed before, especially, I don't know if it'll happen now, but you may well feel under pressure, because sometimes the hospital system will use a Form 5, particularly over the weekends and stuff like that. Access to somebody out of hours can be difficult, and therefore what you get is a little bit more time pressure, that you may be getting the call on day 2 or day 4, and that can put a little bit of pressure on you as well, in terms of what is reasonably practicable to do within the time frame that you have in front of you. So that all of that's quite important to think about. If the person's under 18, the order still applies. The difference could be that we would also need to then be thinking about maybe which hospital they're going to go to, because we do have a specific facility for people under 18. And also you need to be thinking about, is there a corporate parent involved? So for example, if the child's subject to looked after procedures, if the trust has a court order in place, we would be then the nearest relative. So there's other wee things to think about that are important for assessing children as well, and how we then support them when they are brought into hospital. So for example, the code would have talked about discrete accommodation in an adult ward. So if we can avoid placing the child in the adult hospital, we'll do that, but that's not always going to be feasible, depending on bed availability and so on. So there's just some extra things to think about. And you might also want to think about this person being a child in need, and therefore thinking about making a Unicini referral if that's appropriate to do that. It's not always, but you might want to think about that as well. So the conveyance to the hospital, so you've done all your preparation piece, you've interviewed the patient, you and the doctor have a conclusion that detaining the patient is the right thing to do and therefore must go ahead. You need to be thinking about, well, how do we get the patient from A to B? So there's a risk assessment framework in the regional protocol. So have a look at that. There's a red, amber, green bit at the back of that, and I have a separate presentation if you guys want it to help you think about that a little bit more clearly. But basically, you need to get the person conveyed to hospital. It says there that it's within 2 days of the medical recommendation, and up to 14 if that's been extended by a Part 2 doctor. I've never seen this happen. I've never seen anybody delayed in getting their conveyance done. It's usually done the same day, or within a few hours. What you're wanting to think about really is what's the best way to do this. So it can be lawfully done in your own car, as long as you're not traveling alone with the patient, and that patient is basically diagonally opposite to you. So they're in the back seat on the passenger side, and that there's somebody else in the car with you to support that as well. When you're conveying the person using an ambulance, again, you're delegating your powers to them to convey that person, so the paperwork needs to go with the patient to the hospital. So the pink forms that we talk about get handed over to the ambulance crew, and that becomes their lawful authority to keep the patient detained in the ambulance and to bring them to where they need to go. Do you need police assistance with that as well? Again, it's always helpful to have that discussion. If the police are already there, they may or may not be needed to go with the ambulance. Sometimes the police are not there, and the ambulance crew may well feel, yes, that's okay, we'll progress without the police. And other times there'll be risk factors where we'll be thinking, no, we need the police, because police and ambulance crew are better trained at manual handling of patients and restraint techniques. So again, if there's any risks like that, you'll be wanting to have that discussion with them, so that the patient doesn't place themselves at risk or others at risk by trying to escape whilst being conveyed to the hospital in a car or in an ambulance. It's theoretically possible for the police to take the patient to the hospital, but they genuinely don't like doing that because of they're not medically trained. So they're worried about, what if the person stops breathing, what if the person's sedated, what if. So they would prefer not to do that, and some will point to a force order saying that they shouldn't. But again, there are occasions where it might be better for that to happen. So have a good discussion and keep that recorded in your MHOB. That slide just covers pretty much, I think, what we've said as well. Yeah, and that's going back to your point, Hazel, where the nearest relative, where the ASW is not consulted the nearest relative, they must inform them as soon as practically possible. So I think that answers your point from earlier on.
Yeah, okay.
Yeah. So, oh yes, also on your way to the hospital, it's really helpful, and as part of the good practice, that when you notify the hospital of an anticipated time of arrival, so that they can try and get a medic there to assess the patient as soon as possible, and they know which ward they're going to and all of that kind of crack too. So the idea is, you see, that once the patient arrives at the hospital, they should be medically examined immediately on arrival. Now, it usually takes a bit of time for that medic to be tasked to them. There's other difficulties with that. I think under the emergency provisions, there's some extension in terms of the time frames that can happen, but it's basically, you'll be wanting that medic to be looking, giving the patient an examination on arrival. And when they do arrive, you'll see at the bottom of that page, there's a thing called a Form 7 gets signed. That's basically the official piece of paper that says the medic is accepting the patient into the hospital, and that basically at that point, you as the ASW or relevant social worker are normally then free to leave, because the expectation is that you would stay with the patient until they're admitted. So you can see from that slide, there's a number of time scales involved. The nurses holding power and the doctors holding powers. It's the doctors one that I've seen used much more often. I don't think I've ever seen Form 6 in the 10 years that I've been involved with this. The medical practitioner, as you can see, fills in the Form 3, and that must be within the previous, they must have seen the patient within 5 days of signing that form. Likewise, the Form 2 or the Emergency 2, you also must have seen the patient in some way within the previous 2 days. That's now extended to 5. I think the expectation is that we would still try and stick as close to the forms be signed as close as possible to the actual assessment point, not delaying those. Conveyance to hospital, again, has to be within 2 days. It's normally done at that point, but that extension can be delayed, and then also the examination on arrival. So just to summarise again, the key aspects of this assessment are that you must gather as much relevant information in a timely way as you can. You have a responsibility to coordinate the assessment and consider the need for the police and ambulance support either during the assessment or the conveyance. You have to think about the relevant infection control guidance that's in place at the moment and interview the person. You have to consult the nearest relative, and you may then need to inform them about the process and what's happening. You have to discuss with the medic, and it's the medic's responsibility to secure the bed. Remember that it's you need to consider all options, because when we're engaging with somebody's human rights, we need to do it lawfully and proportionately, and that's why you're wanting to look at, is it proportionate to do this, or would it be better to use a less restrictive option? If you're going with the admission, it's your responsibility to ensure the safe conveyance, and it's your responsibility to communicate all the relevant necessary information to those involved in the admission or the alternative care plan. And the way that our trust does that is that we use the MHOB form for, yes, we'll do a verbal handover, all of that at the hospital site, but in our trust we'll also do the MHOB, and that will contain all the relevant information that then gets shared with the medical officer, the lead ASW, yourself, and anybody else involved with the patient's care plan that needs to know about it. And then that finishes up, I suppose, with the completing all the relevant recording and reporting. So within the PARIS system, when you notify people about the assessment that you just typed up, you can trigger it'll go to the people involved with the patient, but you can also send it to the lead ASW and then make arrangements for the GP to get a copy of it as well. So that kind of rounds the whole piece off for us. So there's a wee step-by-step guide there for you to have a wee look at as well. But again, it's fairly obvious what you're going to be looking at with that. I'm not going to go through all of that detail. You can read that later. Again, thinking about the special needs and requirements of the patient, and that could include interpreters, and then your risk assessment as well. You can read those pieces later on as well. So the stage 2 of the process, again, if you're looking at gaining access to the person and they're barricaded in a room or there's some other difficulty, the police will support you as best they can if there's to do with saving life or limb or preventing serious damage to property. They can force entry into a room or premises, but if you need into premises, you could be looking at Article 129. Other professionals can be really helpful as well, especially if the patient already has a CPN or somebody else in the community. It could be really helpful to have them along as well, and providing you with information. And the other thing for your own safety, make sure that somebody within the system knows that you're heading out. So whoever's the coordinator for the day, make sure they know that you're on your way out to this call, and they'll try and keep in touch with you as well, and predict any dangers as reasonably you can before you head out. When you arrive, you do need to identify yourself, so bring your ID with you and make sure other people do identify themselves clearly as well. If the patient's in the hospital, just check the Form 5. What date and time was it signed? What time frame does it leave you with? And if the Form 3 is already signed, just check for any errors or problems with it as well. Now, the only thing you can't do, if the Form 3 is not dated or not signed by the GP, those are errors that can't be rectified later, but all the other errors, minor errors in it, can be. So the lack of a postcode, or the patient's name, middle name and first name the wrong way around, or something, those are considered minor errors. But if the Form 3 is not signed, it's just not signed, and that's a difficulty that you can't rectify. And if you're making the joint assessment, again, discuss how that's going to be led. Some GPs will want you to lead it. Some GPs will want to lead a certain bit of it themselves. So again, have that discussion before you go in. And on some occasions, it might be better to interview the patient separately. It's a judgment call that you'll make at the time. The in a suitable manner, but loads of really interesting case law about this. But basically, it's as private an interview as you can possibly make it. So if it's on a hospital, then pulling the curtains round might be as private as you'll get it. You can't really demand a private room to do this in a busy hospital setting, but equally, it's not ideal to be doing it out on the person's front lawn while the neighbours are all gathering around to watch because there's two blue light vehicles sitting out the front. So there's judgment calls here, but you'll understand as you're professional folks, you know what you're at with that. Stage 3 then, given the opportunity to the person to engage with you about what's going on for them. So you're all well used to doing mental state examinations and discussing this with folks, but just remember things like, why is it that are they behaving violently? Is it because they feel they're being controlled, or is it because they feel that they can be in control and need to do this? Are they experiencing hallucinations, either auditory or visual, that are causing them to do these things, or driving a fear in them that they're reacting out of fear and doing a fight or flight type thing for that? Are they expressing ideas of paranoia, about delusions of being possessed, or morbid jealousy is another one that comes up sometimes from time to time as well. So go through those in detail with the person if they're able to do that with you. And then also be mindful that there could be other reasons contributing, like substance misuse or alcohol misuse, other difficulties, maybe learning disability, other disinhibited behaviours possibly. Maybe they grew up in a culture where violence was normal, or violence to them has been normal, or maybe just living the accommodation that they're living in as well is causing all sorts of other social factors to factor into the difficulties that they're experiencing. I know that personality disorder is ruled out of the kind of mental health order, but an awful lot of those folks do have other underlying mental health conditions. They, as part of their personality disorder, may find it really difficult to express what their mood and their thinking and their actual mental health disorder is. So don't allow the one thing to mask the other, or to drive your assessment in one direction. The other thing you'll want to think about is the previous history of the patient. Has the person displayed similar behaviours like this before and then gone on to be exceptionally violent towards others? So if you know that's been a pattern, really important that you think about the likelihood of that pattern re-emerging within the next few days. And are you then trying to prevent that person from behaving in that way by detaining them now? Again, try not to interview the patient on your own. It's not always possible, but it's a good idea to have somebody with you, and especially if you're aware of other violent risks, you will be wanting to discuss those with the police. Now, the police will go back to that regional protocol thing, and they'll ask you about, well, when did they make the threats? Did they act on them, and so on? If it was a week ago, police are unlikely to come with you. If it was this morning, then they will be more readily agreeable to come with you to protect you and others. So again, timing of threats, timing of behaviours is important for that regional risk assessment or regional protocol. And then when you do arrive, make sure you park your car so that you're ready to follow the ambulance if you need to, but also ready to escape if you need to, either from the room, from the house, or from the street as well. Just bear those pieces in mind. The interview is crucial, and you're well practiced at this. It's not different to what you've already been doing given your length of experience within mental health, and you're wanting to ask questions that are, getting to the heart of the matter about identifying the risk and working out who's at risk, and also what safeguards may or may not be in place or available to you to consider all the options available. Consulting with the relevant others, we've kind of covered that as well, and the other professionals, and then detailing what the risks are. I think we've covered most of those in the discussion already. When you're informing the nearest relative of the outcome of your assessment, do that at the earliest opportunity. So if they're with you, advise them straight away. If you're having to contact them later, when's the most practicable time for you to be able to do that? And it might be the same day, because they have rights and responsibilities as well that you need to tell them about, particularly around their right to, yes, they have a right to object, but they also have rights in terms of appeal for detention within the hospital as well. If the nearest relative has requested the assessment, so again, that's about if the nearest relative has asked you to do this, you need to come back to them in writing to say why you did or didn't go ahead with the detention. And again, informing the GP in any case. And the patient and the nearest relative both have rights of appeal, and you need to make sure that those rights are the person's advised of those rights. Now, best practice would be that you have leaflets that you can give to each of these folks about their rights. We have those available within the trusts. They're available in, I think, 7 or 8 different languages as well. Each of the trusts have shared these around. So as a bare minimum, you would be wanting to hand those, post them to them, but also make sure what the hospital do. Sometimes people will be advised of the rights 2 or 3 times. That's safer than not advising them at all. And then that's the form for the 2A. And then, or the emergency 2, and the 2A is on the right of the screen. And you have a free narrative bit then to record some of the nearest relative things for you on the 2A. So the conveyance, again, you can read that at your leisure, but if you're not going in the ambulance, you need to follow as close behind as is safe to do so, and make sure that the forms go with the patient. The other thing that's really quite helpful as well is quite often the GP will print out a little bit of the patient's own medication and their recent contacts with the GP. So if that printout's available, it's really helpful to send that with the ambulance crew along with the pink forms, and then the ambulance crew will hand that over as a bundle to the admitting nurse usually, before the Form 7 gets signed. So that's really quite helpful to have that. As I've said, contact the hospital and let them know that you're on your way and what time you think that you're arriving. But then you need to be thinking about, if we're removing the patient, we're removing them from their own home. So we have a duty to make sure that the things that they're responsible for or own, that we look after those. So can we get the property secured by a family member, or do we need to sort that out ourselves? What about the patient's responsibility in terms of childcare arrangements? Do we need to think about the broader family structures that will help with that? And what about any pets, animals or livestock that the person's responsible for? Do we need to make arrangements for those? Again, the trust will support you in making those arrangements as best we can, but you would have the responsibility to make sure that gets done. And then you need to accompany or follow the patient to the hospital, hand over all the documents, and as I've said, remain with the patient until they are medically examined, or sorry, remain in the hospital until they're medically examined. Most of us would actually go to the nurse's station quite after the patient's been brought in, because the nurses will help settle the patient to their room, and we can take that opportunity then to go to the beehive and start on our paperwork, the MHOB report, and it gives you a good opportunity to engage with the doctor at that point as well before the Form 7 gets signed. So and that you can be there for maybe an hour or more before the doctor would be available, so it's a good use of time to go in there and get the MHOB sorted out. And it gives you the chance to engage with the nursing staff verbally as well as you're going through the form. Oh yes, have I told you about this? And it kind of helps with you building up that form as well, as getting good quality information to the nurses. If you couldn't contact the nearest relative, as we said earlier, contact them as soon as practically possible and then complete your report. And that MHOB report is get your hands on it soon, read through it, see the process the way it's laid out, because it's structured in a good way. Pay particular attention to the bit about the admission. Really helpful in the admission section if you can actually record the staff, the member of the doctor's name and their grade as to who completed the Form 7, because that can become a prompt for how long the person can be held on the Form 7 before the next one gets done. And also there's a follow-up section there. So did you get back to the nearest relative? Did anybody else need to get informed? And some details in that follow-up section. So that helps remind you of that. Loads of people like flowcharts. So Gavin's provided us here with different flowcharts from the GAIN thing. Again, they're available online, but that's the one for the community setting. That's if the person's already in a general hospital setting, but not the emergency department, because that would be the previous slide. If the person's already in a psychiatric or learning disability hospital, that's kind of the flow that would happen there. And then that's the flow of the application process. So the Form 3 is the recommendation. That then triggers an application by either yourself or the nearest relative. My advice would always be that it's better for the relationship between the client and the nearest relative if the ASW or the relevant social worker makes the decision or makes the application. Some folks will want to do it themselves, but it can have a knock-on effect longer term for their relationship with the patient. So my advice is always take that risk away for the both, and if you think it needs done, then you be the applicant where possible or where appropriate. The conveyance piece is there again to remind you about that, and then also just a reminder about the resources that came with this pack as well. So I'm not sure, I don't have a clock in front of me, so I'm not quite sure what the time is, but
that's great. That's great, James. I'll just pause the recording for a moment.
Yeah.
Okay, so we're recording again, so that's great.
Yeah, so these are some case examples. It's going to be under part 3 of the program that we've been putting together for you. We'll let you read those slides at your leisure, but it's basically a reminder of what we've already talked about. So the key bits for this would be this particular case study. So you're a relevant social worker and you're contacted by a GP who's requesting an assessment under the mental health order. The person involved is a young guy called Michael. He's 17 years old. He lives with his parents and older sister, and the GP explains that Michael's parents are worried about him, and they report that over recent months he's been spending most of his time alone in his bedroom. He's reluctant to eat with the rest of the family. He's been going out to see friends, or he hasn't been going out to see friends as he would have done before. He's staying up late at night, and he hasn't been going to school and stuff, and he's missing out on A-level preparation. So they suspect he's been using drugs over the past few months, but they're not certain of any of the details around that. And he hasn't been going out of the house, so they don't think he's got access just at the moment. They report he seems to be report that when he does respond to efforts to engage in a conversation, he appears to be preoccupied with unusual ideas about the government, capitalism, global elite, and the need for him to fight these powerful forces. So he said that they are monitoring him, but he won't specify who they are. And his parents also say that he now wears his headphones most of the time, and they've heard him shouting and singing loudly in his room at early hours of the morning. The GP said that they have seen Michael recently at his parents' request, but that Michael didn't say anything really, and he was fine and sat with his head down during the consultation and reluctant to make eye contact. His father phoned her to say they've had a very difficult exchange with Michael. He's refused to come out of his room, and he's threatening to kill anybody who will come into his room. And his father reports that Michael appears distraught and has screamed at both parents, saying that he wishes he hadn't been born. He's now barricaded the door of his room with heavy furniture, and he's refused to see the GP again, and he says he wants to be left alone. So how would you prepare for that? What factors would you conduct your assessment, and what would you consider, and also what are the possible outcomes? So let's have a wee chat about that then. So how would you prepare for the assessment? Who would you be wanting to contact?
The GP.
Yeah.
The parents.
Okay.
The GP. Sorry, Stephanie.
Sorry, Hazel, I was going to suggest there any key worker as well, if he was known.
Yeah, and who might he be known to, do you think?
CAMS?
Possible, yeah.
Would you contact the school maybe for information? Or would that be a confidentiality thing?
If I was contacting a school, I would probably want to speak to somebody like the designated teacher rather, or somebody in the pastoral care side of things. But given that he hasn't been going to school, there might be an education welfare person already involved, and it might be wiser to go to them rather than going to the school. It's always a difficult one contacting schools. I mean, what do you think, Gavin? But designated teachers tend to be reasonably okay. But
yeah. I mean, obviously, you would, in terms of contacting people, you would always usually be doing that with the relevant people's consent. But I mean, as you know, if there's sufficient concern, and really it suggests if you're being asked to assess someone under the 86 order, there is sufficient concern to contact others without their consent.
Okay.
Given that the school doesn't have any recent information, I'm not sure I would actually, now that I think about it, would go to them. The recent information really lies with CAMS if they're involved, home treatment team if they're involved, GP definitely, and parents, and possibly the sister if she's over 18. You might want to have some discussion there, but I would limit it to the people who have the recent stuff, because it's the recent stuff that I think you're going to be basing your research upon.
Okay.
So in terms of conducting the assessment then, where and how is that going to happen?
Well, it looks like you're going to be outside the bedroom if you can't get into it.
Okay, are you allowed to do that?
Well, you would try and get him maybe to speak to you, but if you can't, you might have to.
Yeah.
Through the door or...
So because you can gain access to the house, I think Article 129 would not be relevant. However, if this was a house of multiple occupancy with 5 students living in it, and each one of them has their own private room, then Article 129 might be applicable, because the premises you're talking about is the bit of the building that they occupy solely, and they're responsible. So houses of multiple occupancy can be a wee bit of an anomaly, but anyway, we'll skip on with that. So you're sitting outside the door. Well, I'm saying I'm sitting outside the door on the floor trying to chat to this fella through the door. Would there be anything that would provoke you to look for that door to be put through?
It's according to if he was saying something that you believe that he was going to do himself immediate harm.
Yeah, and how significant would that have to be, do you think, before the police would, well, I've given you the answer, but how significant would it be before the police would actually, if they were even on site, actually put the door in? What would they be looking for?
Well, was there any previous history?
Okay, yeah. But what are they, they're looking for risk to what before they'll put a door through?
Him harm himself?
Yeah, so risk to life.
Yes.
Okay, that's the sort of thing that they're looking, or that he's going to severely damage some of the property. So if they can hear things getting broken and damaged,
okay,
destroyed, they may put the door through. Or if there's any indications that he's going to physically threaten his own life, then they'll maybe do that. Yeah.
And it can be useful to refer specifically to that. So it's under the Police and Criminal Evidence, Northern Ireland Order 1989. And as James has said, it's for the purpose of saving life or limb or preventing serious damage to property.
Yeah.
And there could also be, in very, very extreme and unusual circumstances, if the police weren't present, you could also, if you had sufficient concerns that, for example, Michael's ability to sort of make the relevant decision was impaired by him being unwell, and that you needed to really try and save his life, essentially, that you could also use force. I mean, the protection then would be under the common law, but because it would be necessary to act in that way, but it would be very, very unusual circumstances.
Mm-hmm. I've only ever seen it happen once, and actually the family didn't want the police coming into the building because of where they were, and the person had barricaded the door, and the family put the door in on the say-so of the ASW, who were saying, look, we're worried about what he's doing to himself in there. He has access to this and that. It's possible he's actually harming himself. And on the basis of that, well, we actually did think he was. So the family then put the door in. But if you do use pace to get that done, then the police become liable for the repairs. Whereas if the family did it, then the family have to sort it themselves. So again, there's those sort of things that do weigh on people's minds, because I was asking the family not to put the door in, to let the police do it. Oh no, we can't have the police in our house. We'll just do it ourselves and we'll pay for the door. So yeah, but anyway, that's so.
Would you be thinking about, James, the fact that he was possibly using drugs in the past, to then, or that he's maybe having some sort of, he's clearly having some sort of, sounds like, psychotic episode. Would you try and talk to him about that and about him going voluntary?
Well, I think you're leading on to my next question, which is what are the factors that you want to ask him about? So why, I mean, surely telling parents to stay out of the room and I'll kill you if you come in, I mean, it's not that abnormal for some teenagers, possibly.
No.
Certain families to be behaving like that. So so it's crucial that we get to understand what's going on in Michael's thinking at the moment.
Yeah.
So what sorts of things are you wanting to ask him about?
Just how he's feeling, or what he's been, what's been going on with him, why he's saying these things, maybe what is, what's going on in his head.
Yeah, because lots of teenagers believe in conspiracy theories.
Yeah.
But is that harmful? I suppose I'd encourage you to think about, well, so you've said that you're going to have to fight these powerful forces. Tell me what does that fight look like to you?
Okay.
Yeah.
Greta Thunberg is fighting powerful forces, but I don't think anybody would be thinking of detaining her for wanting to do that. So it's all about what's the perspective and what's the level of control behind what's been said to him and what he's perceiving. So you see where we're going?
Yeah.
With that, yeah. Any other factors you'd want to think about?
Maybe if he wanted to speak to you without the parents outside the door, maybe asking the parents to leave and reassuring him that you were speaking to him and the parents weren't hearing what was being said.
That's if that's practicable and safe to do that, then I wouldn't have a problem with that as well. The other thing you'd be wanting to think about is he's refused to talk to the GP. So, in this particular case, does the GP need to be part of the conversation? Let's say the GP saw him yesterday or even 3 days ago. Is absolutely crucial to get this GP in this house at this point in time to interview this patient, when theoretically he may well be willing to, or she may be willing to sign the forms based on what they've already seen.
Yes, and bringing the GP in today might completely upset the entire situation.
It might, yes, or you might decide, actually, I do want the GP here today because GP can say, well, when I saw him 72 hours ago, he was placid, and yet today this is a very different presentation. So that becomes more evidence of your risk factors. So those are the, I'm not going to give you a straight answer, I suppose, but it's about what's the benefit. Does the benefit of the GP being there outweigh the risks of the GP being there?
If he refuses to engage with you, what do you do then? Depending on, if there's no noise in the room, or if you're hearing banging about the room, or what would you do then?
Well, you basically have to rely on the informants that you currently have. So that would be the sister, the mother, the father, the GP.
Okay.
CAMS. So on the balance of probabilities of what they have said to you, what do you feel is the situation right now inside that room?
Okay.
So if it's sinisterly quiet, and you hear nothing inside that room, that you may well feel that that's an indicator that he has already done something to himself, and therefore you must go in. Or you might want to go round to the outside of the house if it's a bungalow and have a look through the window and let him know that you're doing that. So you're only expected to deal with the information you have in front of you. And if he's unwilling or unable to add to that information, then you make your call on what you've got.
Would you check things like, I don't know, if he had a girlfriend and how she has found him over the, because I'm imagining if this is only going on for a couple of months, the chances of him having being seen by CAMS would be very slim in that short time frame.
Yes.
So do you look for outside significant people?
You can do, but again, you need to think about the timeliness of finding them and getting them.
Okay.
You don't want it to overly delay your process, but equally you want to have the balance of enough information to make a decision. Sorry, Gavin, you were going to say something.
It was just a couple of things. It was just to repeat again the part of the emergency code that allows you to consider, in exceptional circumstances, to consider alternative methods of communication. So I think that's mainly thinking about making sure everyone's safe in terms of infection, but this might be an exceptional circumstance where you would consider trying communicating with Michael if he's something in common with most 17-year-olds already on his phone. So just, I mean, mainly presumably to negotiate access to the room, but that might give you a bit more information if he's willing to speak with you via FaceTime or Skype or whatever it is. And also just to sort of reinforce the importance of that initial introduction in terms of you explaining who you are and your role and why you want to talk with him and what it is, why you're going to be asking him all of these questions, just to make that really clear to him. The research is helpful in terms of how valuable, even though you have to do that as part of your role, it also reinforces how valuable that is in terms of the person feeling respected and listened to, and it being less likely that they'll experience this as a very negative or coercive or traumatic process if you do those things clearly, and also make sure that he's aware of anybody else who's there and what their roles are and so on.
Okay.
Okay. We'll have a look at
conveyance and stuff with this. I think just maybe take a couple of minutes just to, if you're thinking of not detaining, what other resources would the trust have available to support Michael or the family? What would you look to there?
The mental health team.
Yeah. Sorry, Hazel, you were going to say something?
I was going to say, if he's 17, consider a referral to CAMHS. If you know, Sheena says if it's only been going on a couple of months, the chances is that he's not engaged with anyone.
Yeah.
To discuss with the GP if that would be an option.
Yeah. And possibly thinking as well about supervision arrangements in terms of, you know, maybe people trying to, you know, be up through the night and listening for him and check, you know, just to provide him with some support or whatever in a suitable way, but also that's going to be sustainable for their own mental health and physical health and well-being as well. So there's a few resources.
Leave the family.
Sorry, Hazel?
I was even going to say leaving the family crisis numbers.
Oh yes, leaving phone numbers is all very, very helpful as well, and how to access support if things change as well. So there's lots of alternatives, and you're balancing all of this up basically on your professional judgment. And one of the safety nets for you is that as long as you're acting within the guide and the emergency code of practice, and you're clearly doing this as best you can within your professional remit, then you're protected in that by vicarious liability as well. So, you know, we make the best decisions we can, and sometimes they're not the perfect decision, but as long as you're acting reasonably in the patient's interests, then you know you will be supported in what you're doing and have done.
Would you have detained him, James? Did you detain him?
This wasn't my question, and I suppose whenever you're looking at this particular case study, the reason for it was to drive the students down the answer of, I think I'll detain this patient. Here's what I need to do about access, conveyance, and but there are occasions very similar to this where I have and I have not detained.
Okay.
And sometimes the having not detained feels more risky.
Yeah.
But turned out to be right. You know, so it's difficult. There's no right answers to these things, I think, to be honest.
James, would it be fair to say sometimes, I mean, your thinking really does evolve in the process of assessment? Sometimes you get information where you think this is very, very likely to result in a mission, and it turns out not to, and other times you think, I'm not too sure what the concerns are here, and it turns out there are very high levels of concern. Is that reasonable?
Oh yeah, I mean, there's one that stands out for me, and that my initial instinct was we had enough resources to make sure we didn't need to detain the person, and we had somebody volunteering to say, well, look, they can come stay with me, and that'll de-escalate the thing. And whenever I turned round, the patient was chasing that person around the car with a slipper in her hand, trying to whack her. So it went from no mission of detaining the patient to, okay, I now just cannot take any further risks. That clearly is not going to happen. I have no choice but detain the patient. So it's a very fluid process, but be confident that when you've made the decision to detain or not to detain, that you'll know yourself what it is that has tipped you in one direction or t'other. And it'll probably be one particular feature that you'll go, that's the missing piece of the puzzle for me. I'm going to do this, or I'm not going to do this. I can think of one particular lady who was so distraught at the thought of not being able to be near her children. Obviously, there's risks to the children and all of that, but it was that level of distress in her eyes that made me think, okay, if we can get you supervised for the next 48 hours and not have a minute by yourself, then I'll agree to this, because actually the presence of her children became a safety feature for her not harming herself. And yet there's other circumstances I probably would have felt actually you being around your children is a risk to them by them seeing you like this. And it's only when you see the whites of the person's eyes that you really get a feel for why am I taking this risk, or why am I going down with conveyance instead. So it's it's challenging work, but fascinating, and I don't regret any of the decisions I've taken. I've been very uncomfortable about a few of them, but in hindsight, we've done the right things.
Okay.
Oh, yeah. Don't be too scared about it. It's good work.
Mm-hmm.
Yeah.
That's easy to say.
It is, and at the time you're kind of, the adrenaline's pumping, and you're, I don't know if we have time to do the second one, do we, Gavin?
Yeah, let's just run through it quickly. I mean, it just raises some possible overlaps with, I suppose, mainly with safeguarding and capacity, but it's maybe worth just mentioning those briefly.
Yeah, so this lady has a diagnosis of Korsakoff syndrome. She's only 55, married, and had been admitted to a local nursing home. And there were some concerns that Iris may have been victim of domestic abuse. She's now been in the nursing home for 3 months, and the family had initially been agreeable to that, but difficulties are now emerging. Her husband, for example, has come to take her out of the facility for several days at a time, and on her return she seems dishevelled and out of sorts. And whenever they've been asked about this, then the husband and the son have become verbally aggressive and abusive towards staff. They've also recently noticed a strong smell of alcohol from Iris, her son, and the husband, and they've been concerned about bruising to her arms and legs. Iris's husband has made it obvious that he wishes her to be at home, and Iris has also stated to staff that she wants to return home to be with her husband. But at the moment, she hasn't returned from her most recent, shall we say, placement home, or planned visit home, and the staff have been unable to contact any of the family. So where do you go from there?
Need to be contacting the key worker.
Okay. Yeah.
Try to make contact with the family yourself.
Okay. Yeah.
Discuss with the GP.
Uh-huh.
They're looking at DLA.
They're looking at what?
DLA. They're looking at money back.
Oh, Sheena, straight to the point, aren't you?
I would say that's quite a bit of it.
It's possibly in the background.
Yeah.
That's a matter, I suppose, where we'll be thinking about adult safeguarding services being involved. Have they
Yes.
been involved already? Possibly.
Mhm.
So there's another team we could be thinking about. Okay. You've been asked to do an ASW assessment. So you've been asked as a relevant social worker to go out and do this assessment. Where and how are you going to do that?
You've been trying to speak to Iris on her own to see what she's saying.
Okay.
I mean,
So how are you going to get to Iris? Do you know where she is?
why will you going to try the home first? Go and try and
Yes.
speak to your husband.
Yeah. So, sorry, tickly cough. It's not a dry one. We're all right. I had those symptoms last week. Right. Any legal authority you might need to exercise here?
Would you take the police with you just in case?
I don't think they'd go
Right.
at this stage. Would there be something that you could get that would make them go?
Emergency protection.
Well, you're starting to think along the right lines, but what you're wanting to think about is, do you remember we talked about Article 129
Mm-hmm.
and the warrant?
Yes.
Okay, so if you thought that she was being kept inside that house, yeah,
Okay.
and that the husband wasn't going, so this is your bit earlier, Sheena, you said, oh, well, I would go to the house. So you're going to the house to see if they let you in.
Yeah.
And if they don't let you in, but you're sure that Iris is there, you might need
Yes.
to think about getting an article of 129 to allow the police to go in. Okay?
But you'd have to go to the house first to see if you would you? Yes.
You would,
Or,
because
yeah.
one of the practicalities of you applying for the warrant would be that you have to name the address as to which you want the police to go into.
But is it James that necessarily Iris is maybe not a danger to herself or others? They're a danger possibly to her. So would you be more looking at guardianship? Possibly.
Guardianship could be a medium-term option, but in terms of what about right now and today, guardianship wouldn't be an emergency response. Guardianship always has to be planned, and the patient also has to be reasonably in agreement with the plan. But yes, guardianship would be an option in this case. But I suppose,
would you be detaining Iris because she's at risk of harm from others?
again, you could be looking at, is her judgment so badly impaired that she's unable to protect herself from others?
Okay.
For her own safety. Yeah.
Yeah. Now, that's not great grounds for detaining her to a mental health hospital for assessment.
Yeah.
Okay. So in this particular case, theoretically, you could look at conveying detaining the person and bringing her into a psychiatric hospital. But what other options do you have available to you within the community?
Could you detain her to ED and then just place her from there?
Well, who would bring her to ED?
The police. The police would have the power to bring her to ED.
Under what authority?
Under the emergency holding powers, or
under the Article 129.
Yeah.
9.
Right.
Yeah.
Okay.
Right, Gavin wants to say something.
Yeah, and just to mention, I mean, again, it's just to sort of remind you a few of the other basics. Even if the risk criterion is met, the mental disorder criterion still also needs to be met. So,
Okay.
for the mental health order to be used. So just to bear that in mind. I mean, if Iris, we know that Iris has a form of mental disorder, but it may not be sufficient to need admission to hospital. So it's just to bear that in mind. And the other thing, I suppose, the other two crucial parts of the process, which we haven't talked about yet, but also relevant to Michael's case, we're identifying who the nearest relative is, and then making a professional judgment about whether it's practicable to inform them to talk with them. So in Michael's case, it's probably, you would need to check this out, but it's probably one of the parents, and if that's the case, it would be the older of the two. And in this case, it's probably, again, we're assuming Iris's husband is the nearest relative, but there might be a consideration if that's the case, and maybe there was clearer evidence than is presented here, but that he was being abusive towards Iris. There might be reasons why you would conclude that it wouldn't be practicable within that appropriate to contact him. It's very unlikely. I mean, you probably would, and you would probably be keen to speak with him for a number of reasons, but it's just to mention those things as well.
Can I ask about applying for a warrant? Now, where does one start with that? I think if I was dealing with this, I would be on the phone to the nearest ASW I could catch about this. So would you be applying for a warrant?
Yeah, that's a slow process, and it can, anytime I've done it, and I've done it twice in 10 years, that's show. I mean, last year I think our trust had 2, and the year before maybe had 3 in the whole year. So it's a very, very rare occurrence.
Okay.
My advice to you would be, whoever, if you feel you need a warrant, contact whoever the coordinator is for the day, and we'll guide you through it.
Okay.
It's a fairly slow process, and again, the police will help with identifying the magistrate, and but it's complex, it's slow. There are other ways to do this, and it's very rare that we would need it.
Okay.
But it allows the police and the GP to go into the house with a view to removing the patient to a place of safety, so that you can assess them there. Now, you can also be invited into the house after the police and GP have gained entry, and you can do the assessment in the house, but normally speaking, you're looking to remove the patient to a place of safety, which would be the ED. So we've talked about safeguarding concerns, we have talked about possible guardianship. You might also want, in this case, consider, would there be grounds for a short-term detention authorisation, for example, to the hospital under the Mental Capacity Act, or the use of some other power within the Mental Capacity Act to maybe have the person deprived of their liberty to the care home through a trust panel. So you can see some of these alternative options will not fall into place quickly. But they do need to be something that I think you would consider. Yeah. Okay. So, Gavin, anything else about that?
No, just to reinforce that, if in any situation, if your conclusion is that the criteria aren't met, that compulsory admission isn't going to be possible and appropriate, then you do still need to consider how all of the issues that have been identified can be best addressed. So just thinking about what the alternative arrangements, including voluntary admission, but also all the alternative possibilities in community settings. So I think we're really sort of at the end of our time, but are there any sort of final sort of questions or comments anybody wants to check out before we finish?
Someone under the age of 18, where do you go to access a bed? Is that to Bluestone within the Southern Trust?
Not normally, Hazel. Normally, for somebody under the age of 18, if they're needing to be detained, we would be looking for a place called Beechcroft in Belfast.
Yes, right.
And the GP would be arranging the bed.
Right.
But if there's no bed available in Beechcroft, then we would potentially look for detention to another hospital.
But Beechcroft is in your initial, but that's up to the GP.
Yeah, I mean, the ideal is that you'll have a suitable facility near to where the patient lives. So suitability for under 18 means a facility for children, for young people. So that's Beechcroft.
Beechcroft.
The next one would be then a facility close to where they live, which would be, in our case, the Bluestone.
Oh.
But there are other things that need to be factored into place, and the bed manager for the facility would be well aware of those and would support you in kind of making sure that, so for example, they wouldn't be allowed to be detained into a facility that had a Schedule 1 offender as a patient. Also, all of those things, that the bed manager would know those things or should know those things. So again, you wouldn't be expected to predict all of that, but certainly you'd be expected to do what you could to remind them of that.
Right.
Okay, listen, I'll just stop the recording here. But again, thanks for letting me do that. I mean, it'll hopefully be of benefit to others. So, thanks again.
Thank you, Gavin and James.
Okay, yeah. Thanks.
For you guys, remember.